definitely indirect discrimination because it deprives her of her right to get elected at the lowest administrative body. And I think in the judgment when we dealt with this in the Supreme Court, we didn't quite apply the concept of proportionality. We also didn't really look at indirect discrimination. We only looked at it as a population control measure. And we said, if the state in its wisdom has said that this is a measure of population control, we should defer to that legislative wisdom. But I think it was far more complicated than that. And I think we need to revisit some of these issues because what seems to be a very straightforward case is really not that. And also in Indian society, the context of Indian society, I think Dr. Ambedkar identified very early on, we have this question of graded inequality. And there are inequalities at several levels. And when it's a question of gender, for instance, it's not just gender. It's a cascading effect of inequality, which we need to address. And some of these techniques would be very useful for us. I think identifying comparators is going to be difficult in India. But if we do, we'll go a long way in resolving some of the complex issues. Thank you.
Permission to chair. I think my brother, learned brother, did not appreciate me. I was in the context of ideological differences. See, Indian conditions, there are hopeless discriminations. To overcome those discriminations, we have discriminatory laws. That's the protecting and to bring the unequal to a level of equal. That is how the objective of the Indian Constitution, and our courts are also working in tandem with the objects of the Constitution. I never meant that the depressed or the underprivileged or these persons who are denied of the rights have to be, those practices have to be perpetuated. So in order to avoid that, we have been working, both the constitutional courts have been, statutes and courts are also working in tandem with the objects of the Constitution. That's what my intention of my statement.
Before I pose the problem to Lord Lester, let me congratulate you for having such a comprehensive legislation. I wish we had such a comprehensive legislation on equality. Sir, my problem requires little preface. The problem of unemployment is prevalent in many countries. India, it is practically endemic. Unemployment means denial of all human rights because one doesn't have the livelihood to enjoy any other rights. In that given situation of unemployment, widespread unemployment, what happens is that government makes efforts to generate employment through its own agencies, through its own departments. And there are specific schemes just to provide employment. Now when such employment is offered, it is by way of largesse rather than a matter of right for the employee. Although he might be working in the same capacity as a regular employee who is so-called regular or permanent employee in the government setup. But when a person is employed under a scheme, he is named differently. Although he is works in the same capacity, does the same kind of work. But often he is called ad hoc, often he is called temporary, otherwise he is part-time, or he is a fixed term employee, or a fixed pay employee, or a daily wager. There are so many epithets that are. In such a situation, under this new law, which I unfortunately did not have the time to go through earlier, but I am really impressed. Thus the law, this new law, provides for equality in such cases where the government is specifically intending to offer employment, but on lesser conditions of service, on inferior conditions of service, where the employee doing the same work for so many years doesn't earn even security of job or equal wages or many other perks which a regular, so-called regular permanent employee gets. Now this is the kind of discrimination. In private employment, it's a marketplace where the demand and supply work. But supply is always in abundance. The demand is less. Therefore, the employees are at a disadvantage. They are not in a bargaining position. But can the government discriminate on the basis that they are opening employment? And therefore the worker cannot demand the same rights or equality with a so-called permanent or regular employee.
Well, there's an easy way of answering the question, and there's a slightly more complicated way. The easy way of answering it is to say that the only forms of discrimination covered by the Equality Act are those set out in the Act. And therefore, unless the difference of treatment that you referred to was on one of the grounds set out in the Act, whether direct or indirect, it would not be unlawful. But the more complicated question is really about socio-economic inequality. Now, the person sitting over on my left there, Kate Reagan, when she was sitting on the Constitutional Court of South Africa, I regard her as the greatest expert on socio-economic rights. So what I'm about to say, I say a bit frightened that she might disagree with me. The way in which the Act sought to deal with this was in section 1 of the Act, which said public sector duty regarding socio-economic inequality. And then there was this extraordinarily windy and unenforceable rubbish. It says, an authority to which this section applies must, when making decisions of a strategic nature about how to exercise its functions, have due regard to the desirability of exercising them in a way which is designed to reduce the inequalities of outcome which result from socio-economic disadvantage. Sounds great, doesn't it? Now, Kate Reagan came to London, even though she was not from the UK, and was introduced to ministers while the Act was being prepared. And we were trying to persuade ministers, I was, to do something about socio-economic rights. There's a South African model, which I'm sure she'll discuss at some point. This was the best that they could think of, and it's unenforceable, and the present coalition government decided never to give effect to it. Now, you of course have directive principles. The Irish have directive principles seeking to deal with the broader kinds of problems. I've never met any Irish judge or practitioner or person who even thought about the Irish directive principles, because they are deliberately made non-justiciable in any event. Your directive principles have a different function. My own view, because I come from a British tradition, is one about separation of powers, which is, I think, that the function of courts is to act as the unelected guardians of law. But on the kind of problems you're dealing with, I believe it's the obligation of the legislature and the executive to have positive obligations so far as wider socio-economic disadvantage is concerned. But under your system, I fully understand that your judges are put in a position of exercising that sort of responsibility. My own view, the kind of problems we're talking about, could be challenged by way of judicial review under administrative law in our system, because our judges have recently recognized, as one of Lord Walker's cases refers to this, that it is a maxim of good government to treat like cases alike and unlike cases differently. And so I can imagine a challenge being made to some such distinction. But I think our judges will be very cautious about using judicial review. They will give a wide area of discretionary judgment to the government or the legislature in cases of that kind, because they would be rightly concerned as unelected judges about separation of powers, and they would be rightly concerned that our parliamentarians in particular and the wider public would think that judges should not take the place of the other political branches of government. So we have this as a continuing matter, and indeed our Human Rights Act has given rise to constant debate about whether the judges are going too far. They haven't, but you hear politicians and the media criticizing them for going too far. In fact, they've been very carefully restrained, and the Carson case is a good illustration of why they should be restrained. And I agree, therefore, entirely with the approach in the Carson case. I can say it because I'm not a judge, but I think that Robert Walker and his brethren and Brenda Hale have been brilliant in the way in which they have developed the human rights in the last decade without usurping the other branches of government. So your case gives rise to all of this, I think, but it wouldn't give rise, I don't think, to a remedy under the Equality Act unless it was on one of the prohibited grounds.
Sir, I have one question. You see, India is a heterogeneous society where various religion and various beliefs are present. Now what happens in a school, the standard of moralities are being provided. Now, certain standard of morality is in contravention to the religious belief of certain religion. My question is, would it result into a religious discrimination? And if yes, how to balance in such circumstances that there may not be even indirect discrimination to the student who is studying in the school?
But in what kind? Sorry.
Can you give me an example?
Suppose a manner of offering a prayer. In a X religion, the prayer is being offered in a particular manner, whereas in Y religion, the prayer is being offered in a different manner.
Oh, I see what you mean. Right. The position of religion in our schools is dealt with by the legislation itself. We have an established church, Church of England, but we also, of course, have other religions and lack of religion. And there is, by statute, a requirement for a daily religious prayer in schools, which can be opted out of. And there are provisions where, in a particular school, if the majority of the school population are not Christian, then their own other systems must be respected. And in any case, there must be respect given for other religions in our plural system. So there are issues as to whether we should have faith schools at all, which are issues more of a political nature. And there is the issue in the Jewish free school case about quotas, but that's about ethnicity rather than religion in that particular case. The real problems that we face about religion from the Equality Act point of view are more, for example, whether a British Airways employee can be compelled by British Airways not to wear a crucifix as a religious symbol in accordance with her beliefs. Held, they can require her not to do so, and it's not discrimination to do so. Or to take another case, we have now, as I said before, civil partnerships that are the same as marriage, but not called marriage, for gay couples. So suppose you have a registrar of marriages, that's to say a public officer, and she says, I have a conscientious objection to registering a partnership between homosexuals. It's against my religious beliefs. can she refuse to perform the statutory duty held by our courts? No, she must perform her duty. She cannot use her religious belief to deny the right to have a civil partnership registered by a public officer. These are the sorts of cases that have caused attacks to be made on our judges, even by a former Archbishop of Canterbury, who should know better, who says they're all biased. They're not capable of deciding religious questions because they become too secular. And there was even an application in a case for the judges not to sit on the ground they would be biased against religion, believe it or not, supported by a former Archbishop of Canterbury in applications to that court. So those are the types of cases where sexuality and religion can, or take another case. Suppose that a religious organization says, we will not employ lesbians, even as cleaning ladies, because we regard homosexuality as evil. Again, there was a leading case where it was held that that was not a situation in which respect for religious belief could go that far. But on the other hand, if you say you can't become a bishop unless you are satisfying religious qualifications, those kind of cases are the easy ones. But this is a minefield, and the Act seeks to draw distinctions and create dovetailing between religion and sexuality, among other things. But it was one of the most controversial issues in making the Act.
Okay, thank
So,
you.
thank you, gentlemen, and may I request Mrs. Palm, Judge of the European Court for Human Rights, to make a presentation on the with respect to her release from the European.
Thank you very much. I will start with saying that it's a great pleasure for me to be here today, and I'm very happy that I have been invited to this colloquium, which seems to be very interesting. And as it is my first time in India, it's very special for me. I have been asked to give a view from the European Court of Human Rights on this issue of equality and non-discrimination law. Some issues have been touched upon by my predecessors here, so I will try not to repeat what has been said so eloquently already, and especially about direct and indirect discrimination. I think it has been covered well by Lord Lester and Lord. The European Court, known by all, but it has now worked since 1959. And it has delivered by now more than 10,000 judgments. And there is now a very solid body of case law where the court has developed interpretation of the different articles of the convention. However, with the speed that the court nowadays delivers judgment, it's a little bit difficult to follow what happens in Strasbourg. And also it's a pity that the court has now there's such a difficult situation with all the backlog it has. I think it's now amounts up to 130,000 cases that are not treated. But happily enough, it has a very good data-based system that I suppose you all know the HRLN. I think that is an excellent system when you try to find case law of the court. During these years, the case law from Strasbourg is followed closely in many countries, also outside the member states. And it has, during the years, influenced many countries' legislations and jurisprudence. When it comes to the jurisprudence concerning equality and non-discrimination, the court has laid down some fundamental principles already in early judgments. The court has thereafter referred to these cases and added more and more, all in performing its task, its well-known task on interpreting the convention as a living instrument. It's well known. I have listed some of the classic cases in this volume that you have before you, and I have taken some of the old ones, but also some of the new cases, the recent one. I will not go into them explicitly, all of them, but I found that these are interesting if you want to study this issue more closely. If you look at the wording of Article 14, you can see that it is not a general prescription against every kind of discrimination. The article presupposes only that it should be possible for everyone to enjoy, without discrimination, all the rights and freedoms which are guaranteed in the Convention. I may put in there incidentally, because I have also served in the Human Rights Committee, the UN Human Rights Committee, and there is, in that covenant on civil and political rights, there is a general independent right to equality in Article 26, and that is far more far-reaching than the Convention, Article 14. But even in the Strasbourg system, it has changed to the better, I would say, since because the Convention has been supplemented since 2005 by an additional Protocol 12 with a freestanding anti-discrimination provision. And in its first paragraph, it prohibits discrimination in relation to any rights set forth by law, in contrast to Article 14's limitation to the rights and freedoms set forth in the Convention. And if you go to the preamble of this protocol, you can see that it refers to the fundamental principle according to which all persons are equal before the law and entitled to equal protection of the law, and confirms that the member states now take further steps to promote equality through the collective enforcement of a general prohibition of discrimination. It also reaffirms that the principle of non-discrimination does not prevent states from taking measures in order to promote full and effective equality, provided that there is an objective and reasonable justification for those measures. This sounds very good, and I hope it will be developed, but so far the protocol has just been ratified by 18 out of 47 members. And the court has examined just a few cases. I will come back to one of them at the end of my intervention. So Article 14 in the Convention is tied to the other subjective rights in the Convention and its protocols. And already in the Belgian linguistic case from 1968, the court said that Article 14 has no independent existence. It complements the other articles in the convention, substantial articles. It has no independent existence since it has effect solely in relation to the enjoyment of the rights and freedoms which are safeguarded by those provisions. And that means that an applicant who is complaining of discrimination must allege discrimination in respect to another right which is protected by the convention. For instance, you can take one of the most common articles in the convention, the Article 6 about fair trial. It is useless to rely on Article 14 and invoke discrimination in respect of a right that is not covered by the convention. Say, for instance, a social right or an economic right. We have been talking about employment and pay here today, this morning, and you can't invoke discrimination in respect of those rights as they fall outside the convention. Then an applicant may establish a violation of Article 14 even though he cannot show a violation of another article, provided that the claim falls within the ambit of the convention right. That is something that the court has developed. So, in a way, they have, you can say, they have extended the scope of the article, because it is sufficient if the case facts fall within the ambit of one of the articles, substantive articles on the convention. One of the earlier cases, well known for most people, is the Abdulaziz Kandali versus the Kingdom, the United Kingdom. It dealt just with this, such a situation. In this case, it was argued that according to the British immigration rules, it was easier for men than for women to obtain a permit to stay with foreign spouses. And the court found no violation of Article 8, that is, there was no lack of respect for family life, but as the facts fell within the ambit of Article 8 and the treatment was discriminatory, there was a violation of Article 14. When the court examines a case where the applicant claims that there has been a violation of Article 14 alone, and at the same time on Article 14 in conjunction with the substantive article, the court had a tendency in earlier cases that to find that it was most necessary to examine the case under Article 14 if they found a violation of the substantive article. But the case law has developed also there, and if the court has said that if the inequality of treatment is a fundamental aspect of the case, the court may first find a violation of the substantive article and then go on to examine whether there was also a violation of Article 14. You'll find that in an old case called Marx case, where the court first found a violation of Article 8 taken alone, and then went on to consider whether there was also a violation of Article 8 in conjunction with 14. The court seems in the more recent judgment follow this path. For instance, there is a case of called Sahin versus Germany that could be prove that. Now one could ask, if every difference in treatment amounts to a discrimination, that would, I think, lead to unreasonable results. The article, because as we have said here before, the article sometimes also protects the inequality that might have been designed for to benefit the less privileged. So not every different treatment is prohibited on that article. The court has stated that it was in the Belgian linguistic case that the principle of equality of treatment is violated if the distinction has no objective and reasonable justification, and the existence of such justification must be assessed in relation to the aim and effects of the matter under consideration, and regard being had to the principles which normally prevail in democratic society. A difference in treatment in the exercise of the right laid down in the Convention must not only pursue a legitimate aim. Article 14 is likewise violated when it's clearly established that there is no reasonable relationship of proportionality between the means employed and the aim sought to be realized. Now, these words are well known, and but I repeat, I mention them here because the court, the way the court writes its judgments, it's always that they refer to earlier case law, and some of these cases, like the Belgian linguistic case, the Marx case, and some other, are so often referred to. So I thought it could be of interest to have the text here. Now, it can be difficult to decide whether the situations are equal or unequal. In a typical discrimination case, an applicant will try to compare himself or herself to others in a comparable or analogous situation and claim that he has been treated differently